He murdered 2 people, and he convinced a jury he was too jacked up on junk food to know what he was doing. And it worked. I'm about to tell you the most twisted legal loophole in America, one that's been letting violent criminals escape justice for decades, all because they were too drunk or high to mean it. Picture this. You get wasted. You hurt someone bad. Next day in court, your lawyer stands up and says, "Judge, my client was too messed up to understand what he was doing. No intent, no crime." And sometimes it actually works. It's called the intoxication defense, and there are 2 flavors. Involuntary intoxication, when someone spikes your drink or you get roofied, whatever. That's a complete pass. You could walk away from because you genuinely had no control. Voluntary intoxication. You choose to get hammered. This only works for specific intent crimes where you had to plan something specific like premeditated murder or burglary. Regular assault, you're still guilty because being drunk doesn't excuse throwing punches. In 1978, Dan White, a former cop and San Francisco city supervisor, gets into political fights with Mayor George Moscone and Harvey Milk, the country's first openly gay elected official. White wants his supervisor job back, and they say no. So he takes a gun, extra bullets, climbs through a basement window at City Hall to dodge the metal detectors. He walks upstairs and he shoots both men dead, point blank. He reloads between victims. Open and shut murder case, right? This was premeditated execution. Nope. His lawyers claimed White was too depressed and sugared up on junk food to form murderous intent. The media dubbed it the Twinkie defense, even though Twinkies were barely mentioned in court. The jury bought it. Voluntary manslaughter instead of 7 years. He served 5. San Francisco's gay community lost their minds. The White Night riots tore through the city. California was so embarrassed they scrapped their entire diminished capacity law.